Hello, I would like to welcome you on behalf of the Early Years and Childcare Advisory Team to Session 1 of the Foundation Training for Safeguarding Children. My name is Lucy, and I am just one of the Early Years and Childcare Advisors who will be guiding you through this recorded session today. So if at any point you need to pause to revisit slides, make notes, take a break, or complete tasks within your workbook, please do so at your leisure. However, you must ensure that you have watched the entire Session 1 plus completed all workbook activities before you attend the live Session 2. If this session raises any questions, please record them in your workbook and bring them to Session 2, where the Early Years and Childcare Advisors delivering the training will be happy to discuss. Alternatively, you may wish to raise queries directly with your designated safeguarding lead. The aim of the course is to provide the knowledge required by all those who work with children in an early years provision of your safeguarding roles and responsibility towards those in your care. We need to ensure that we safeguard all children effectively. Let's start by considering what safeguarding is. There are both proactive and reactive elements which sit under the umbrella of keeping children safe. Within working together to safeguard children, these are referred to as help, support, and protection. Safeguarding is proactive. It has many elements which work together to ensure children are growing up in circumstances consistent with the provision of safe and effective care, as well as protecting them from maltreatment. Early help is support for children of all ages that improves families' resilience and outcomes or reduces the chance of a problem getting worse. You have a legal duty to protect the children in your care, but safeguarding is done in partnership with families and other professionals, including all those listed on the slide. Child protection is reactive. It forms part of safeguarding and promoting the welfare of children. It refers to the activity that is undertaken to protect specific children who are suffering or are likely to suffer significant harm. Whilst the duty to deliver support and services for the local authority, other safeguarding partners, like those on the slide, play a critical role in the delivery of services for children and their families. The National Society for the Prevention of Cruelty to Children, NSPCC, has a website with lots of information to further support you in this area. We have added the link to the supporting information pages of your workbook. It is imperative that we maintain a child-centred approach to safeguarding. But what does this mean in practice when we are working directly with children and families? Working together to safeguard children states that a child-centred approach is fundamental to safeguarding and promoting the welfare of every child. Within early years settings, this means that practitioners know your children really well and are able to recognise changes to their normal, whilst also knowing what is important to them, their interests, and family dynamics. An effective key person system allows children to build strong attachments with adults. As they spend time together, they get to know each other, sharing stories and listening to what is important. Keeping the child at the heart of what we do and not being distracted by the wider needs of the family may be difficult at times, but as we know, the welfare of children must be paramount. Children are clear about what they want from an effective safeguarding system. I will now read what children have said as recorded in point 13 of the Working Together document, and you should use these requests from children as a guide to support your practice and behaviours. Children ask for vigilance to help adults notice when things are troubling them, for understanding and action, to understand what is happening, to be heard and understood, and to have that understanding acted upon, for stability, to be able to develop an ongoing stable relationship of trust with those helping them, for respect, to be treated with the expectation that they are competent rather than not, for information and engagement, to be informed and involved in procedures, decisions, concerns, and plans, for explanation, to be informed of the outcome of assessments and the decisions and reasons when their views have not met with a positive response, for support, to be provided with the support in their own right as well as a member of the family, for advocacy, to be provided with advocacy to assist them in putting forward their views, for protection, to be protected against all forms of abuse and discrimination, and the right to special protection and help if a refugee. Children ask for all of these things, But how can we recognise difficulties for them if we do not know what the expected child development is? It is therefore important for all practitioners and professionals working with children to have knowledge and understanding of expected child development when it comes to safeguarding. If practitioners have a strong understanding of when to expect children to develop certain abilities, or have the maturity to understand certain situations, the more likely they are to recognise when something is wrong and pick up on children trying to tell their story. For example, you might expect an active 2-year-old to have bruising along their shins. However, the same bruising on a child not yet walking would cause concern. You may need to be mindful of injuries which occur as children develop and learn new skills, and those which may be passed off as accidents by adults. Considering Maslow's hierarchy of need, if a young child is not provided with basic physiological resources such as food, water, clothing, sleep, and shelter, this will detrimentally impact on their ability to learn, therefore falling behind the expected developmental norms of children for their age. In addition to physiological needs, children must also feel safe and secure, be loved, and feel a sense of belonging with a strong self-esteem before they are able to meet their full potential. These needs are not being met in a home where abuse is taking place. If all those working with children have a true understanding of child development, they will be able to recognise when a child is falling behind and then focus on understanding why this might be. We often need to ask ourselves, is it a learning delay, special educational need, or is it safeguarding? I would like to briefly cover protected characteristics. There are 9 characteristics which are protected against in law. The 2010 Equality Act combined many previous legislation, but still covers the same protected groups as before. These are religion and belief, sex equality, sexual orientation, pregnancy and maternity, age, marriage and civil partnership, gender reassignment, disability, and race. This means that it is illegal to discriminate against any person or third party on these grounds. Within early years, it would be classed as discrimination if you were to refuse to register a child in your setting due to their parents having one or more of the protected characteristics. For example, a child with same-sex parents must legally have the same opportunities to access childcare as those with heterosexual parents. Before you continue, please ensure that you have looked at and completed Activities 1 and 2 in your workbook. I am now handing over to my colleague who will follow up on bullying and discriminatory behaviours.
Bullying and discriminatory behaviour. Consider what bullying is, how it affects the people involved, why people bully others, what bystanders should do when they witness bullying, and the importance of children telling someone if they or someone else are being bullied. The Anti-Bullying Alliance definition is: bullying is a subjective experience and can take many forms. Bullying is the intentional physical or emotional hurting of one person by another, where the relationship involves an imbalance of power. It is usually repetitive or persistent, although some one-off attacks can have a continuing harmful effect on the victim. It is crucial that we make a clear distinction between relational conflict, which is friendship problems, and bullying behaviour, and when bullying behaviour becomes a criminal act. It is also important to be aware of the many forms it takes, including verbal abuse, non-verbal behaviour, ostracism, as well as taking of property and physical assault. Other types of bullying include cyber texting and online bullying. You should have policies and procedures in place to cover bullying and discriminatory behaviour which are shared with parents and carers. The procedures should cover what you as a practitioner should do in the event of this happening with children, staff or even parents. You also need to consider what support is in place for both the victim and the perpetrator, as obviously they will both need support. Remember that bullying is an imbalance of power, and with that in mind it's hard for a young child to bully. This is likely to be more about young children's friendship issues, emotional understanding and self-regulation. Remember that if you label a child as a bully, they may live up to that label, so be very careful. British values. British values, what are they and where do they come from? Fundamental British values form part of the Prevent theme of the Government Anti-Terrorist Strategy Contest. British values were first introduced in schools and early years settings in 2014 when the Department for Education published its British Values Guidance, stating the purpose as to create and enforce a clear and rigorous expectation on all schools to promote the fundamental British values of democracy, the rule of law, individual liberty, mutual respect, and tolerance of those of different faiths and beliefs. One of the reasons for British values are so important is that they help to prepare young people for life in modern Britain as they grow older and leave school. Another reason is that they form an important element of safeguarding children, as they are intended as a preventative measure against extremism and radicalisation. It is important that you are clear on and know how to ensure these values are taught to children in your setting and embedded in practice. I will give you some examples of what each value might look like in an early years setting. As you listen, think about how you demonstrate in practice each British value in your setting. Be prepared to feedback in session 2. Democracy. Children, parents and staff should have the right to have their voices heard. For very young children, this may be through observation and following children's interests. For older children, this could be about asking for their involvement in making decisions in an age-appropriate way. Parents should be given the opportunity to share ideas, express any concerns or queries. Rule of law. This is about children understanding the need for and following rules and expectations. In practice, this may include developing golden rules with the children, staff modelling positive reinforcement and praise, as well as giving older children an understanding of why a rule is in place in an age-appropriate way. This will also include providing opportunities for children to understand and express emotions, as supporting self-regulation will help children to understand about right and wrong and taking responsibility for their actions in time. Individual liberty. This focuses on promoting freedom of choice and the right to respectfully express views and beliefs in a safe environment. Children should be supported to become as independent as possible, allowing them to make choices and take risks in an age-appropriate way. This also includes promoting children's self-esteem, encourage them to have their own ideas and respect those of others. Mutual respect and tolerance of others. Children should have opportunities to learn about different cultures and beliefs to reinforce messages of respect and tolerance in British values. This will also allow them to understand that others may have religions and beliefs that differ from their own and to respect these different viewpoints. This will help create an ethos of inclusivity. Safeguarding children with special educational needs and disability. All children and young people, including those who are disabled or have impairments or additional needs, deserve the opportunity to achieve their full potential and to be protected from harm so that they can flourish. Research on the protection of children and young people who are disabled indicates that they are more at risk of abuse than children and young people who are not disabled. This can be for a variety of reasons. Children and young people with SEND may have communication difficulties that make it difficult to tell others what is happening, and they have no support around their speech and language difficulties. They may have an impaired capacity to resist or avoid abuse. They may be isolated and have limited contact with others. They may receive intimate care from a number of carers, which may increase the risk of exposure to abusive behaviour and make it more difficult to set and maintain physical boundaries. They may lack confidence and be inhibited about complaining for fear of losing services, or they may not even realise the services are abusive. They are especially vulnerable to bullying and intimidation and more willing to accept bullying due to lack of recognition of those issues. They may also be more vulnerable than other children to abuse by their peers. It is also important to be aware that attitudes and discrimination can mean that only a child's disability is seen. This can result in the child's condition being used to explain concerns rather than keeping the child at the centre and considering whether in fact the child is being harmed or at risk of harm. For further training, go to NSPCC Learning, who provide a course called Safeguarding Children and Young People with SEND. NSPCC are well known for their expertise in safeguarding children. This e-learning course will help you to identify safeguarding concerns, communicate effectively with children and young people to help keep them safe and create a safe culture in your setting. You are hopefully aware of Dingley's Promise, which all BCP practitioners can access for free. This is a programme of training designed to empower early years practitioners to deliver inclusive practice by upskilling them through training, shared information and learning resources. It is expected that the training will increase learners' awareness of the needs of all children, especially those with special educational needs and disabilities, and increase confidence in supporting the learning and well-being of all children in their setting. Information about all this training and how to register is in the workbook. There is also a link to Safeguarding Disabled Children from the Pan Dorset Safeguarding Children Partnership Policies and Procedures Manual for further reading. Neglect. Neglect is the most common form of abuse. 1 in 10 children in the UK have been neglected. Concerns around neglect have been identified for more than half of children who are the subject of Child Protection Plan. Neglect is the most commonly mentioned form of abuse by adults contacting the NSPCC helpline. As you can see on the slide, there are different types of neglect. Prenatal neglect. This can be associated with factors including drug and alcohol use during pregnancy, smoking during pregnancy, failure to attend prenatal appointments or follow medical advice, and exposure to domestic violence. Emotional neglect. Emotional neglect occurs when children are deprived from their emotional needs of forming secure, positive attachments with adults. Parents may struggle to meet children's emotional needs due to a variety of reasons, such as depression or drug and alcohol abuse. A few examples of emotional neglect include humiliating a child, rejecting a child, or giving bizarre forms of punishment. Supervisory neglect. Supervisory neglect occurs when the adult responsible for a child either fails to supervise and keep the child from being harmed, or fails to have someone else supervise the child and keep them safe from harm. This type of neglect can occur continually or only happen one time. 2 examples of supervisory neglect include failing to supervise a child around dangerous circumstances and leaving a child with an impaired caregiver. Nutritional neglect. Nutritional neglect occurs when a child is undernourished or is repeatedly hungry for long periods of time. Lack of calorie intake can be evidenced by poor growth. Poor nutrition has negative consequences on the child's physical and psychological development. If proper nutrients are not available at critical growth periods, the child's development will not follow the normal and usual pattern. Physical neglect. This type of neglect occurs when children's basic physical needs such as food, shelter and clothing are not being met and often occurs in a persistent pattern. Examples of physical deprivation include being denied food and or water and being left out in the elements. Medical neglect. When medical neglect occurs, children are denied the medical care they need to treat a condition or prevent an illness from worsening. A child may be repeatedly refused medical care for an ongoing condition or may only be denied for one instance of required medical care. Failing to secure medical attention for an injured or sick child or not following medical advice are both examples of medical neglect. Educational neglect. This is when children are not given access to education. The Department for Education has stated persistent failure to send children to school is a clear sign of neglect. The NSPCC has cited failure to ensure regular school attendance, which prevents the child reaching their full potential academically, as one of their 6 forms of neglect. Persistent and severe absence are recurring themes in safeguarding practice reviews. In contrast, regular school attendance is a protective factor for the most vulnerable children and young people, providing opportunities for support whilst giving them the best possible start in life. For further information about neglect, please refer to the Multi-Agency Child Neglect Strategy and Toolkit on the Pan Dorset Safeguarding Partnership website. The link is in your workbook. This updated strategy brings together the work of representatives from a wide range of local service supporting children and their families to improve their lives into adulthood. We ask you to ensure that the toolkit is disseminated and adopted within your setting. We know that when children and young people are subject to adverse childhood experiences, including neglect, not only does this impact on their development, but it will also have enduring consequences throughout their lives and potentially the lives of their own children. Susan Miller, Neglect Activity 3. Please pause this recording to watch the Susan Miller video. The link for it can be found in your learner's workbook. Whilst listening to the audio clip, please consider the different types of neglect and complete Activity 3 in your learner's workbook. We will discuss this further during Session 2. Once you have completed this activity, please rejoin the session.
Please pause this video to watch the Adverse Childhood Experience video. The link for it can be found in your learner's workbook Activity 4. Whilst listening to the video clip, please consider the impacts and complete Activity 4 in your learner's workbook. We will discuss this further during Session 2.
Please stop the presentation and listen to the PANTS video. The key message is that simple conversations can keep children safe from abuse. Following disclosures, children need to be believed and to be validated, to be given the emotional and practical support, to be treated like a normal child and not be stigmatised. Advocacy needs to be had, and that's to help navigate processes. Your response is crucial. Poor responses by recipients of disclosure can result in a minimisation or retraction of disclosure from the child. It means that the child may fail to disclose later, may leave the child in danger, delay help, and the potential for mental health and well-being difficulties in the future. Studies tell us that children think that they are disclosing abuse even if they aren't directly verbally communicating it. 2/3 of sexual abuse occur within the family home, and this is from the Children's Commissioner. Sexual abuse within families is most likely to be carried out by brothers, stepbrothers, 38%, followed by fathers of 23%, and other male relatives, 22%. Stepfathers and partners, 13%, and mothers, 4%. Quotes from the PANTS campaign. The victim said, "I never went to ask for help, but no one ever asked me." And from parents, they said, "You don't think that the sexual abuse will ever affect your family, but it could, so you need to talk to children about it and to be able to protect them." We would now like you to pause the slide to complete Activity 5, Main Categories of Abuse, and Activity 6, Indicators of Abuse in your workbook. You will need to have the What to Do if you're worried a child is being abused document. Please follow the link in your workbook. We will discuss these further in the live session.
Across BCP, we have 2 mechanisms to support families with domestic abuse: PPN, which is a Public Protection Notice, and MARIC, a Multi-Agency Risk Assessment Conference. Public protection notices are sent to early years providers when any domestic abuse incident has occurred in a child's household and the police have attended. A PPN is highly confidential and you should never speak to a parent about it, as the information that you receive is very limited and you will not be able to work out who is the victim or who is the perpetrator. The purpose of the PPN notification is to raise your awareness. If you already have concerns, this may add another piece to your puzzle raising your concern and triggering further safeguarding support. Or it could be that you are not aware of anything going on and therefore you'll be more vigilant and make sure the proper support is in place for the child. The police will speak with social care and early help. They will then contact our funding team for details on the child, and that is how settings are then identified from the child that attends. Your designated safeguarding lead will determine what action, if any, needs to be taken. Note that only children who receive early education funding can be identified, so any child not receiving funding where domestic abuse occurs in the household, you will not be made aware. The other mechanism for support for families with domestic abuse is the Multi-Agency Risk Assessment Conference. Again, it is highly confidential. The conference, which is determined by the risk of each case, will be held with other professionals such as health, police, BCP early years representatives, probation and education. Sue Goddard, who is the early years safeguarding representative for providers, also attends, and you may be called upon to contribute by submitting written information. You may also hear the term HRDA, High Risk Domestic Abuse Arrangements. This is the term used by Dorset instead of Marriott. There is a domestic violence disclosure scheme. It's called Clare's Law and was introduced in 2009 following the murder of Claire Wood by her ex-boyfriend who had a history of violence against women. Her family fought for the rights that people should be able to inquire with the police for any history they have around abusive behaviour on a person, so people can be better informed on the people in their lives if they have a genuine concern. You can advise potential victims of this scheme regardless of gender, and it is for anyone in an intimate relationship. Anybody can make an inquiry and the information will be given to the person at risk or professionals who are in safeguarding. The scheme enables potential victims to have access to information about the history of their partner so they may make an informed decision about the relationship. Online requests can be made via dorset.police.co.uk or by calling 101.
You are now going to have the opportunity to do your own research on the wider safeguarding considerations. These are forced marriages, child sexual exploitation, female genital mutilation, safeguarding children from abroad, including modern slavery and human trafficking, assessment of risk outside the home, contextual safeguarding, extremism and radicalisation, including prevent duty, abuse linked to spiritual, cultural and religious beliefs, honour-based violence, domestic servitude, gang activity, youth violence and criminal exploitation affecting children. You have been given the link to the Pan Dorset Safeguarding Children Partnership in your workbook. Use this guidance from the Pan Dorset Multi-Agency Safeguarding Procedures to support you with this activity. Section 2.1, 2.2 and 2.3 will help you. On these areas, please make sure that your notes include definition. So what does that mean? Who would be at risk to this? And signs and symptoms. So what are you seeing and hearing to make you feel that they are at risk? Learners will need to complete this activity and be prepared to feedback in the live session too.
We also need to be alert to upskirting, homelessness, children with family members in prison, children in the court system, child-on-child sexual violence and sexual harassment, mental health and well-being, self-harm and suicidal behaviour, children missing from education. Upskirting is a highly intrusive practice which typically involves someone taking a picture under another person's clothing without their knowledge, with the intention of viewing their genitals or buttocks with or without underwear. Homelessness. To be legally defined as homeless, you must either lack a secure place in which you are entitled to live or not reasonably be able to stay. Children with family members in prison. There are 310,000 children who have a family member in prison, and there are 10,000 visits to prison by children each week in England and Wales. Children in the court system. Children are in the court system for many different reasons. It could be parental disputes over the upbringing of children, local authority intervention to protect children, decrees relating to divorce or the dissolution of the civil partnership, financial support for children after divorce or relationship breakdowns, some aspects of domestic abuse, adoption, surrogacy, forced marriage, female genital mutilation protection. Child-on-child sexual violence and sexual harassment. Child-on-child sexual abuse is a form of child sexual abuse which is a prepubescent child is sexually abused by one or more other children or adolescents. Mental health and well-being. Your mental health and well-being is about your thoughts and feelings and how you cope with the ups and downs of everyday life. Self-harm and suicidal behaviour. In the UK, suicide is the leading cause of death in young people, accounting for 14% of deaths in 10 to 19-year-olds. Self-harm is a common precursor to suicide, and children and young people who deliberately harm themselves may unintentionally kill themselves by accident. But not all young people who exhibit self-harming behaviours are at high risk of suicide. Children missing from education. Children and young people of compulsory school age who are not on a school roll and are not being educated otherwise. Now I am handing you over to another colleague.
Section 47 Inquiries. A Section 47 inquiry is initiated to decide whether and what type of action is required to safeguard and promote the welfare of a child who is suspected of, or likely to be, suffering significant harm. These following slides are to give you some information on the types of intervention that may be put in place to protect a child. A Section 47 child protection inquiry means that children's social care must carry out an investigation when they have reasonable cause to suspect that a child who lives or is found in their area is suffering or is likely to suffer significant harm. The aim is to decide whether any action should be taken to safeguard the child. According to the Children Act 1989, consent is not needed from parents at this point. Police powers of protection can be put in place for 72 hours only. Emergency protection orders can be put in place for 8 days, but must go through the courts and can only be renewed once in court. Section 17 Inquiries. A child in need is defined as a child who is unlikely to achieve or maintain a satisfactory level of health or development, or their health and development will significantly be impaired without the provision of services, or a child who is disabled. Section 17 of the Children Act 1989 is support for more complex needs. Without support, there would be an impact on best outcomes for that child or young person. A child in need assessment under Section 17 will identify the needs of the child and ensure that the family are given the appropriate support in enabling them to safeguard and promote the child's welfare. Disabled children who are open to portage services are entitled to a child in need assessment to ensure that their needs are being met. The consent of parents and young people of sufficient age and understanding is therefore required for agencies to share information or to hold a child in need meeting. Child in need continued. Children in need may be assessed under Section 17 of the Children Act 1989 in relation to their special educational needs, disabilities, or as a carer, or because they have committed a crime. For children whose parents are in prison and for asylum-seeking children. When assessing children in need and providing services, specialist assessments may be required, and where possible should be coordinated so that the child and family experience a coherent process and a single plan of action. Early help. Professionals should be alert to the potential need for early help for a child who is disabled, has special educational needs, whether or not they have a statutory education healthcare plan, known as an EHC plan, is a young carer, is bereaved, is showing signs of being drawn into antisocial or criminal behaviour, including being affected by gangs and county lines, and organised crime groups and or serious violence including knife crime, is frequently missing or goes missing from care or from home, is at risk of modern slavery, trafficking, or sexual and or criminal exploitation, is at risk of being radicalised. This definition comes from Working Together to Safeguard Children 2023. These may fall into early help, but there may be factors which increase the risk or your worry, so it's important to consider all of your knowledge. Early help continued is viewing problematic and/or inappropriate online content, for example, linked to violence or developing inappropriate relationships online. Is in a family circumstance presenting challenges to the child, such as drug and alcohol misuse, adult mental health problems, and domestic abuse. Is misusing drugs and alcohol themselves. Is suffering from mental ill health. Has returned home to their family from care. Is privately fostered child. Has a parent or carer in custody. Is missing education or persistently absent from school, or not in receipt of full-time education. Has experienced multiple suspensions and is at risk of or has been permanently excluded from school. Private fostering is the term used when someone who is not a parent or close relative, for example, great aunt, cousin, mum's friend, or a neighbour, is looking after a child or young person under the age of 16 or under 18 if they're disabled, for 28 days or more in their own home. It also covers children who stay at a residential school for more than 2 weeks of the school holidays. A relative is defined in the Children Act 1989 as a grandparent, uncle or aunt, whether by full blood, half blood, or by marriage or civil partnership, sibling or step-parent. Victoria Columbier is an example of private fostering. Current arrangements for the regulation of private fostering originate from concern following the death of Victoria Columbier in 2000. Victoria was privately fostered by her great aunt. Data on private fostering is gathered annually by each authority and published nationally by the Department for Education. The Continuum of Need is located on the Pan Dorset Safeguarding Children Partnership website and is a valuable resource to support our understanding of levels of need and support avenues for our children and families. It is helpful to think of this document as your development matters for safeguarding children. It is a shared resource used by professionals across BCP and Dorset. There is a Continuum of Need pre-recorded workshop available through Skillgate. The workshop will provide you with an in-depth tour of the document. The document contains levels of vulnerability and need, a flow chart to support decisions, indicators of need, and sources of further information. Each area is broken down into Universal, Universal Plus, Universal Partnership Plus, and Specialist. The document was last updated in February 2023 and will be reviewed again in September 2024.
So let's go through each one of these briefly. The Child's Act 1989 gives every child the right to protection from abuse and exploitation and the right to inquiries to safeguard their welfare. This means that it is more important than either the parent's views or the views of any other adult involved in the child's life. The Children's Act 2004. This saw a drive of working with parents as partners and multi-agency working with other professionals is a development from the 1989 Act. This Act's ultimate purpose is to make the UK a safer place for children and allow for the creation of the Children's Commissioner, as well as each local authority needing to appoint a Director of Children's Services. Equality Act 2010. This legally protects people from discrimination in the workplace and in society. It replaced quite a few confusing anti-discrimination law and made one single act. The Act makes it unlawful to discriminate against someone on the grounds of any of these characteristics: age, disability, gender reassignment, marriage or civil partnership, pregnancy and maternity, race, religion or belief, sex, their gender, and sexual orientation. these are often referred to as protective characteristics. Children and Families Act 2014. The Children and Families Act 2014 takes forward the government's commitment to improve services for vulnerable children and supporting strong families. The Act will reform the system for adoption, looked after children, family justice, and special educational needs. The document What to Do If 2015. This advice is non-statutory and has been produced to help practitioners identify child abuse and neglect and take appropriate action in response. Children and Social Work Act 2017. An act to make provision about looked after children, to make other provision in relation to the welfare of the children, and to make provision about the regulation of social workers. The Children and Social Work Act has four main purposes: improving decision-making and support for looked after and previously looked after children in England and Wales, improving joint work at the local level to safeguard children and enable better learning at the local and national levels to improve practice in child protection, to promote the safeguarding of children by providing for relationships and sex education in school, enable the establishment of a new regulatory regime for the social work profession in England. Working Together 2023. Working Together 2023 is a statutory guidance for multi-agency working. It exists to highlight the expectations of working with agencies in your local area and on a national level to keep children safe. The emphasis on professional judgment, early help, fears about sharing information must not get in the way of protecting children. Contextual safeguarding. Information sharing advice for practitioners 2018. Advice for practitioners providing safeguarding services to children, young people, parents and carers 2018 supports frontline practitioners working in child or adult services who have to make decisions about sharing personal information on a case-by-case basis. Keeping Children Safe in Education sets out the legal duties you must follow to safeguard and promote the welfare of children and young people under the age of 18 in schools and colleges. Safer Working Practice 2022. The document seeks to ensure that the responsibilities of senior leaders of educational settings towards children and staff are discharged by raising awareness of illegal, unsafe, unprofessional and unwise behaviour. It should assist staff to monitor their own standards and practice and reduce the risk of allegations being made against them. It is also recognised that not all people who work with children work as paid or contracted employees. The principles and guidance outlined in this document still apply and should be followed by any person whose work brings them in contact with children. Pan Dorset Safeguarding Children's Partnership, which replaced the LSCB, exists to make sure the key agencies work together to safeguard and promote the welfare of children in Dorset. The key aims are to protect children from maltreatment, prevent impairment of children's health or development, ensure that children are growing up in circumstances consistent with the provision of safe and effective care, undertake that role so that it enables those children to have optimum life chances and enter adulthood, successfully promote a safe environment free from violence. Statutory framework. This sets out the standards which all early years providers must meet to make sure children are given the optimum opportunity to progress and develop in a safe and healthy environment.
Let's look at who has parental responsibility and acting on behalf of. A mother automatically has parental responsibility for her child from birth. A father usually has parental responsibility if he is either married to the child's mother and listed on the birth certificate after a certain date, depending on which part of the UK the child was born in. Births registered in England and Wales. If the parents of the child are married when the child is born, or if they have jointly adopted a child, both have parental responsibility, and they both keep parental responsibility if they later divorce. Unmarried parents, An unmarried father can get parental responsibility for his child in one of three ways: jointly registering the birth of the child with the mother from the 1st of December 2003, getting a parent responsibility agreement with the mother, or getting a parental responsibility order from court. Same-sex parents and civil partners will both have parental responsibility if they were civil partners at the time of treatment, for example, donor insemination or fertility treatment. For the same-sex partners who are not civil partners, the second parent can get a parental responsibility by either applying for a parental responsibility, if a parental agreement was made, or becoming a civil partner of the other parent and making a parental responsibility agreement. So what is parental responsibility? All mothers and most fathers have legal rights and responsibility as parents, known as parental responsibility. If you have parental responsibility, your most important roles are to provide a home for the child, protect and maintain the child. You are also responsible for disciplining the child, choosing and providing for the child's education, agreeing to the child's medical treatment, naming the child and agreeing to any change of the child's name, and looking after the child's property. Parental responsibility for separated parents. If you have parental responsibility for a child but do not live with them, it does not mean that you have the right to spend time with your children. However, the other partner must include you when they're making important decisions about their lives. You do not always need to get consent of the other parent for routine decisions, even if they have parental responsibility. If it is a major decision, for example, one of you wants to move abroad with your children, both parents have the responsibility, and this needs to be done in writing. You can apply for a court order if you cannot agree, and a judge will then make a decision which is in the children's best interest. You must make sure that your children are financially supported, whether you have parental responsibility or not. Pause the slide now and complete Activity 8, Parental Responsibilities. There is a link in your workbook to help you complete this task. And Activity 9, Issues that impact upon parental capacity. Parenting capacity is a broadly defined term that refers to the ability of parents to meet the needs of their children. So when completing the activity, what could be a positive and a negative factor that might impact on the parent's ability? Organisational responsibilities in early years in childcare. Early years providers must ensure that they are alert to any issues of concern in a child's life. Be professionally curious and have an open conversation with parents and their main carers right from the start. You have a duty to make inquiries if there is any reason to suspect that a child or young person is suffering or likely to suffer significant harm. This will enable decisions to be made to whether any further action should be taken to protect. Managers need to have clear policies and procedures to safeguard children, and staff need to have a good understanding of these. Policies and procedures need to include an explanation or action to be taken if there is any safeguarding concerns. What documentations do you use to record this? Actions to be taken when there is an allegation against a member of staff. What is the procedure? Would you know who to contact to raise any concerns? The use of mobile phones and cameras in settings. Do you have clear guidelines? Where should they be stored? And when can they be used? That staff complete the appropriate safeguarding training within their roles. Every 3 years for the foundation safeguarding, and every 2 years for the multi-agency, which can be done through Dorset Nexus. Have up-to-date knowledge of safeguarding issues, and recognise the signs of potential abuse and neglect. Now pause the slide and complete Activity 10, Safer Working Practice. Reflect on your own behaviours and experiences, and we will go over the answers that you have put in the live session too. A link to the guidance for safer working practice is in your workbook. It is beneficial if you find time to read through this document. Activity 10 is the last activity to complete in your workbook, but please continue to listen and take notes as we talk you through online safety and effective safeguarding recording paperwork. Use of information, communication and technology. Let's go through useful supporting guidance available to you. Online safety guidance document is to provide advice and guidance about safer working practice with regards to online safety to ensure that children are kept safe and not to be put at risk through inappropriate use of technology or practice. Your personal and professional lives are to be kept separate. You use your work equipment, tablets, computers, laptops and mobiles for work purposes only. Adopt responsible behaviour that should protect you from putting yourself and your career at risk. Key points. Restrict access to computers and laptops and make sure that they are encrypted in line with current policies and guidance. Send emails securely and confidentially. Do not give out personal information such as phone numbers and email addresses. And never include inappropriate materials, photos or information upon any personal websites or social media platforms. For more information, read the BCP Early Years Online Safety Guidance, and the link is included in your learner's workbook.
Effective safeguarding recording paperwork. Over the next 5 slides, we shall be reviewing the BCP recommended safeguarding paperwork. However, if you are not already using it and use another form for recording, do keep listening as we go through these slides, because we are also talking about how to record safeguarding concerns effectively. If you want to upload the forms first, you can find them on the website highlighted in blue under the heading Record Keeping Forms. Note, we will be using acronyms when speaking, so please make a note to refer back to. DSL stands for Designated Safeguarding Lead. DDSL is Deputy Designated Safeguarding Lead. The blue writing which says Early Years Safeguarding BCP Council.gov.uk is our link to our Early Years Safeguarding webpage. You should familiarise yourself with all of that content. Here you'll find information for designated safeguarding leads, key documents and guidance, multi-agency risk assessment conference and public protection notice forms, online safety, prevent, record keeping forms, and that's the forms that we are going to be reviewing, resources, support materials and online training, updates and latest information and other useful websites. The first sheet, the front sheet safeguarding child protection form, must be fully completed at the point when a safeguarding or child protection form is commenced for a child. This includes when information is received from a previous setting and or other professionals. The first part of the form is self-explanatory. Let's move straight to the box that says any other names by which the child is known. The child may not be using their legal name to that on their birth certificate or for a cultural purpose. The box that says any other family members. Here you would enter siblings or cousins who are also attending the setting. So if you make a referral to social care, they may have information on other people that are associated with the child or the family. The next boxes are self-explanatory. Any other child protection files, you tick a yes or a no. If any other files are held and you've ticked a yes, then you add where the files are and which are the relevant files. You add social worker or lead professional, the GP, the health visitor if they have one. The date the file started is exactly the date that you start to write this form. This is the Incident of Concern form. It is a record of a concern, suspicion or allegation of a safeguarding nature, including those relating to children arriving at the setting with a pre-existing injury. Should be recorded using this form at the time or as soon as possible after the event. However, it's not advisable to make a written record whilst a child is disclosing abuse, as this may deter the child from speaking. Remember when speaking with the child the TED questions. These are open-ended questions. Tell me more about that. Explain what you mean. Describe what happened. Records should be factual, using the child's own words where a disclosure is made. At no time should a child be interviewed, and this may prejudice further investigation and compromise any legal action. You must share this form with your DSL on the day that you write it. You must sign and date and record the time of completing the document. You need to make sure you find out when the event happened, it will give social workers a time frame in order to manage the risk effectively. It will help to inform the next steps. For example, if the incident happened a few months ago, it is highly likely you may be asked to speak with the parents. This is a continuation from the previous slide, as the incident of concern form is just one form. To note, if for whatever reason you're unable to record the information yourself, as you may be out on an outing, you can call the DSL or the Deputy DSL and they will fill in the form on your return, but you will need to read and sign and date to say that this is a true account of what you said. You will see there's a box on the form for you to use. In the very last box, which states contact made with other professionals, add here if you did or if you didn't, but you do at a later date, then you can add this to the chronology form, which we will look at later. And you will also need to use Appendix 1 form, which we will look at later. The incident of concern form must be fully completed on the day of any incident occurring. Think about the impact that may happen if you do not share the information. If you're unsure, contact First Response RLE Help. They are there to give you further advice and they are there to bridge you to the MASH team. The person reporting needs to check back with the DSL that something was done, that they may not give you all the details, but to reassure you that something has been done. This is the incident of injury within the provision form. A record of an injury sustained whilst at your setting should be recorded using this form, at the time or as soon as possible after the event. Remember, a body map marking the injury must accompany this form each time it is completed when you are recording an injury. Body maps cannot be used on their own. You must also make sure that you keep any other appropriate records of injury sustained within your setting, as set out by your insurance company, Ofsted and any other relevant parties. Contact Form Appendix 1 is completed when sharing the Incident of Concern form and or Incident of Injury within the provision form with other professionals. Here you complete the relevant sections about other professionals you have involved. You will also record when you have made the parents aware of any consultations or referrals, and they will need to sign this form. The first section if you have had a discussion with the child's nominated social worker. The second section if you have spoken with First Response and they have said you need to complete an interagency referral form. The third section if there are any other professionals you have had to speak with, like a health visitor or family support worker. And the fourth section if you're referring the information to another professional to deal with, for example, housing or SALT. You must get the names and contact details of people you speak with. The further information box, which is the last one, can be used for any other comments you need to add. For example, if you need to share information at a later date due to an escalation of concerns, this section can be used to explain your professional decision-making process and timing. This is the chronology form. Entries must be made on the chronology form from all Incident of Concern forms and Incident of Injury within the provision forms. This will ensure all information is easily accessible and provides a clear timeline of events and facts. The chronology must also contain records of all professional discussions, emails sent and telephone calls. You must complete all relevant boxes. That includes the date and time of recording the entry and a brief overview of the incident. The source box is where you state where the recorded information can be found. However, if you just want to note a concern which you feel does not warrant writing a form, you can put a brief summary in the event incident box, and in the source box just say no form recorded and you would put your full name. Remember that all recorded child protection concerns must be passed to the DSL. The MASH team have told us that the chronologies are a really good way of presenting information. They have strict timeframes to work within. Remember, often it is only when a number of seemingly minor issues are taken as a whole that a safeguarding or child protection concern becomes clear. There should be nothing that parents are not aware of unless you've been advised not to share information by the MASH team in order to protect the child. Remember to write up the information as soon as possible. Writing must be legible and can be read by anyone who does not know you. Needs to be professional, with no assumptions or opinions, evidence-based and factual. Spelling, grammar and punctuation needs to be right, as this can alter the context of the sentence, so people reading it may not read the information in the correct way and draw different conclusions from what is written. Remember, whatever you write, you may need to explain why you wrote it. This might be in a week or a month or even a year's time. Don't use specialist jargon or acronyms. Don't use woolly words which are vague and open to interpretation. For example, he came in with inappropriate clothes. Think what assumptions others can make from that. It would be better to write, he was wearing shoes that were 2 sizes too big, which kept falling off when he walked. There, you can fully understand what someone was trying to say when they wrote inappropriate clothing. It's very clear and concise. Make sure everything around the discussions are recorded, telephone calls and emails. So if you've taken the form to your DSL, they may say no further action is required. You record that on the form. If they say you need to do something, then you record it. Remember, you have the right to make sure your concern is being followed up. The DSL can also challenge MASH or the first response if they feel their concern needs action. This is an escalation policy you can use. Don't be afraid to challenge sometimes. Someone may not always fully understand what you're saying or get the bigger picture. You can see on the screen the first page of the Pan Dorset Escalation Policy. This is a 9-page document and can be found on the Pan Dorset website, highlighted in blue. If we record effectively, information is factual and evidence-based. It will be clear to all the readers. Information can be shared in a timely way, and we can accurately share our information and concerns. If we do not record effectively, information may be based on thoughts and feelings and not evidence. Information may be unclear to the readers. Information may not be shared in a timely way, and the information we are sharing may not be recognised for what it is meant to be. Sharing information with other settings. When a child leaves your setting and moves on to a school or another setting, you should be transferring over their records. Consider how you do this securely and make sure you get the name, the date and the signature, if possible, of the person you are transferring them to. All safeguarding records should go as originals with the exception of the Incident of Injury form, which is the form that records injury sustained within your provision. These ones you need to keep the originals of, but send photocopies along with safeguarding records, as these forms you may need to keep for insurance purposes. For a complete guide on using the forms and other key documents, go to the BCP Early Years Safeguarding webpage. Thank you for your time. Please ensure that all workbook activities are completed prior to session 2. This is an essential aspect of the overall course. If this session has raised any questions or clarification is needed, please bring these with you to session 2, or if you're concerned about the welfare of a child in your care, speak with your designated safeguarding lead immediately. We look forward to seeing you in session 2, where you'll be able to share and discuss your answers to the activities that you completed in your workbook. Your workbook also needs to be shared with your team leader or manager and or the DSL if you work in a group provision, or if you're a childminder assistant, share with the DSL of your setting. Remember, childminders and DSLs, if this has raised any further questions, please do not hesitate to discuss this with your allocated early years and childcare advisor. Thank you and goodbye.